Arbitration, M&A arbitration. So in transactions, my experience is once you make the statement, oh, what's going to happen in arbitration, how am I going to enforce this clause, etc., many professionals say, don't even say that word. So it's like a cursing word, but in the end, it's part of our life. It's part of our life as M&A professionals. So my pedigree is M&A, but my first experience started 15 years ago, and then I said, oh my God, I had to have a sense of arbitration, and then I personally had some good and less good experiences in arbitration. But we are here to share our experience, what happens in arbitration. And I feel myself very lucky. I have very distinguished two speakers here. Professor Ziya Akıncı, legendary arbitrator in this country. He's the chairman of Turkish ICC National Committee, where I'm sitting just as a member, and he's our chairman there. And he's now the chairman of the new Istanbul Arbitration Center as well. He's for me, the father of Istanbul Arbitration Center. And then, of course, another very distinguished colleague and friend, Yalın, arbitration partner in White & Case. Some people ask me, why do you invite your competitors? If the competitors are good, you try to be better, and it's a great opportunity. So we shouldn't be afraid of arbitration, and we have to learn about that more, especially on those days where we are talking about the rule of law as we started today. Rule of law in Turkey, how does it apply? The situation in the courts and all these things. So, many people say, Hocam, what do you think? Oh, arbitration is too expensive and it takes too long, and it's not a very common way of dispute resolution. What is your experience on that, Hocam?
If I may, thank you very much for the generous introduction. That makes me very embarrassed, by the way. Well, I think I wouldn't blame anyone who talks about arbitration not very friendly, let's say, because you have been talking about M&A. Talking about and practicing M&A is like flirting or getting married, this excitement. But talking about arbitration is like talking about divorce. So nobody would like to talk about divorce or think of divorce, but this is the reality of the life, whether you like it or not. So therefore, arbitration is still a friendly and very efficient solution of the disputes, not only national-wise, but also for international disputes, especially for the international M&A projects. Arbitration is almost the default resolution of the dispute.
Yalın, tell me, so you have a lot of litigation experience as well.
Yes.
Okay, as an experienced lawyer in this country, do you prefer arbitration or litigation, and why?
Okay, so I also repeat the words of the professor, and I'm honored to be here with you, and thank you for the introduction. As you said, we most of the time work with foreign investors, and we deal with both litigation and arbitration aspects of international projects or projects that have multi-jurisdictional aspects. I'd like to start actually by talking about a very recent and a striking experience we have had in relation to this saga or the hesitation between arbitration and litigation. Now, yes, everybody is to some extent prejudiced about arbitration for different reasons in Turkey. But I disagree with those that have this prejudice against arbitration, and I think, as we're going to discuss more later today, arbitration is not an enemy but a friend of you in multi-jurisdictional, especially in multi-jurisdictional.
For the transaction counsels as well.
Exactly. And as we'll discuss more today, I believe it can be used as a tactic in many ways. Let me tell you about this striking example we have had. Our M&A department was representing a client in an M&A transaction. We were going to be the potential buyer, and during the negotiations, the parties agreed upon Turkish courts. We recommended our client to go to arbitration.
Court.
Yes, we had recommended to go to arbitration for that project, but our client wanted to give up on that point to take some other points in the SPA, so they accepted the Turkish court's suggestion of the seller, and we signed the SPA. And several months after we signed the SPA, our client decided to walk away from the transaction because certain condition precedents were not met and would not be met, and the long stop date had passed. And therefore, we walked away from the deal. We did not close the transaction, and we were confident that we would not. We had a confident analysis, so we were confident that we would not have any issues. But the other party ended up suing my client in Turkish courts. So a very funny thing has happened while we were at the second hearing of that litigation. The counsel of the other party, who was a commercial law professor, realized that the judge himself actually had no familiarity with an SPA and with the fundamentals of an M&A transaction. So during the hearing, that professor, as a good tactic for his client, ended up saying that, "Dear judge," these were exactly his words, "Dear judge, the concept of condition precedents, long stop date, closing, these are things that happen in American jurisdictions, US, UK jurisdictions, but they are not allowed in this country. They are against our public policy." So we were relying on the condition precedents and the long stop date, but the other party said those concepts that we were relying on were unenforceable, not allowed in Turkey. So the judge, who was seeing probably the first time in his life an M&A dispute of that sort, turned to me and said, "Mr. Akmenek, to be honest, I also don't have a lot of familiarity with M&A disputes as well." So the judge decided to appoint a panel of experts and has asked the experts whether the very basic fundamentals of an M&A transaction, closing, condition precedents, and the long stop date were concepts that were allowed under Turkish law. And it took the experts 1.5 years to confirm that those were actually concepts that were allowed under Turkish law. And then after 2 years, we started arguing the merits of the case, which were recently concluded for the benefit of our client. But that was the forum we were in. I mean, the judge had no fault, because obviously this was the first time he was seeing that sort of an M&A dispute, so he didn't know what to do and he was not familiar with that. So basically, especially in a complex M&A project, if you go to Turkish courts or any other courts, as may be the case in some other jurisdictions, you may end up with a tribunal that's not an expert in the things that you want to discuss, and therefore you may end up not having exercised your rights, your contractual rights properly. And I think that's I mean, we were the lucky ones because we ended up winning despite those difficult issues, but that I believe is a big issue we had, and had we gone to arbitration, we wouldn't have those.
Question to the audience. Have you ever been in a court? If yes, please raise your hand. Ever in a court? Wow, so many people. Okay. Do you have a prediction how long a court hearing may continue? A regular court hearing. Who says more than an hour? No one. Who says more than 5 minutes? Approximately still 5 to 10 minutes. A regular court hearing in this country takes 5 to 10 minutes. Let's guess how many court hearings a regular commercial judge may have in this country. Simple calculation, approximately 50, 5-0. And you expect from the poor judge to come to a conclusion based on this thick agreement, which is in a foreign language, and deal with the concepts which are not very familiar to a Turkish lawyer, the long stop date, CPs, and closing. Hocam, you are the most preferred Turkish arbitrator in this country. I'm sitting in the ICC committee, and I know that this is the reality. He is the most preferred Turkish arbitrator ever in Turkey. What is your experience? How long does your hearing last, hocam?
My last hearing took 15 days in Dubai, and only Sunday was allowed as an off day, so it was a long time. In fact, it was long for us, I have to say. It was extremely tiring, but normally a normal arbitration hearing takes 1 full week, and I mean, the parties are given the full opportunity to be heard, and also witnesses. And it is amazing how the truth come out when you have the opportunity, especially by cross-examining. I experience Dr. Esten's cross-examination. That is not very easy for the witnesses. This is really very helpful for the arbitrators to hear the witnesses, hear the experts, and also the parties' oral presentation, of course.
And how common is it? For instance, Hocam, how many currently, of course you're not going to disclose the names, how many ongoing arbitrations, in how many arbitrations are you involved personally? Today?
As an arbitrator or?
Arbitrator or counsel?
Both.
Yes.
Okay. I think currently 8 cases as an arbitrator and maybe 10 cases as counsel work.
Today there are 18 pending arbitration cases in Turkey or with a connection to Turkey. Can we say that?
That's right.
Most probably you don't know that because it is confidential and this is why you go to arbitration. Otherwise you go to the court and what happens? It's open to the public.
Exactly.
Huh?
Exactly. And then, for instance, in another case we have, which involved minority investors that were suing our client in Turkish courts. Some of the confidential provisions of the underlying agreements were obtained by those investors, and then they were all across the press because the judge refused to issue a confidentiality order, and this is something that never happens in an arbitration.
Indeed. So in the end, it is really very common. I think we have, one is about to come to an end, we have 5 ongoing matters at the moment as counsel. And 2 as arbitrator. In one of them we are together, Hocam. I have the honor to be your co-arbitrator. And I know you are quite busy on these days too.
Yes.
So it is a very common way of settlement of disputes. And the good thing is that many people say, oh, arbitration is not very common in Turkey. In fact, it is. I have an interesting experience as well. Some years ago, it was, I think, 2008 or so, an M&A transaction subject to Turkish court. And after 2-3 years of litigation, the parties have, or the judge has decided to appoint an expert. And they couldn't agree on the expert, and both parties have appointed one expert. Interesting enough. Me and another professor, Haluk Burcuoğlu. Just to prepare the expert report took us a year because it comes as a file. You cannot hear what the people are saying. You cannot really touch the case. You just have everything on paper. And to prepare our expert opinion took us a whole year. We submitted that to the court. After 6 months, the court sent the file back to us for additional questions. For those additional questions, we have spent another year. So in 2010, in a way, we sent the file back. And just recently, 6 months ago, the Court of First Instance came to a conclusion on this award on the first instance level. Until it comes back from the Court of Appeals, if you're lucky, it takes a year, at least.
Probably more.
If you're lucky, at least a year, and in many cases even more. And then the court talks about the case again and goes back to the Court of Appeals. So we are talking about roughly 10 years. Is it exaggerated? What do you think, Yıl?
In complex disputes, I think from step 1 to the final conclusion, I think in a complex M&A dispute, 10 years is not exaggeration, unfortunately.
Hocam, an arbitration complex deal, how long could it take?
Well, normally it's supposed to be 1 year or 1.5 years. There are some bad examples, but I think 1.5 years is the expected standard time. But 1 year for a commercial arbitration is normal for complex cases, 1.5 years. I think more than length, in Turkish litigation, the expert issue is really a problem, and I just would like to compare it with the arbitration practice. I mean, we have colleagues in this room and they experience it almost every day. What happens in Turkish litigation is if there is a dispute, the court refer the dispute to the expert practically, and the question is who is the rightful party and what is the amount. I mean, this is incredible. But in arbitration, it is true that there are experts' opinion, but almost all the time, the parties appoint the experts, and the experts are instructed for specific questions, not a general question, and then each party has the right to cross-examine the expert. So this is really very different. Not only the land, but the proceeding is very difficult. In Turkish court practice, unfortunately, for Turkish courts, expert is like sub-litigation. You know, they have the opinion of the experts. If they don't like it, they have another opinion, and then one of them become the judgment. This is very dangerous.
Can I?
Maybe one more comment, excuse me, Yalın'cığım, one more comment. Normally, a judge does not stay in the same court for 10 years in a row in the Turkish practice. So in the end, if your judge is replaced by another one after your 4th or 5th year of litigation, the next judge most probably is going to start from the scratch. So in the end, 10 years is really not exaggerated at all in my experience. Please, Yalın.
No, I was just going to add one more thing as to this argument between arbitration versus courts. Now, very recently, a very comprehensive research has been published. This research was published by Queen Mary University, and it was done by Queen Mary University and another international law firm, which I won't name here. And it took Queen Mary University 15 months to interview approximately 1,000 different individuals. And those individuals were in-house counsels, investment bankers, leading figures, government officials, arbitrators, judges, private equity executives, and all types of people that were involved in multi-jurisdictional projects and so. And given the results of the survey, currently in international projects or in projects that have a multi-jurisdictional angle, 91% of those people that were interviewed think that arbitration is the best dispute resolution method. 10 years ago, this was approximately 60%. 5 years ago, this was approximately 75% or so, and now we're standing at a 91% arbitration-friendly result, and the trend seems to be going higher and higher in a pro-arbitration way. So these people have all experienced, these people that were interviewed have all experienced different things, different litigations, different arbitrations, or sometimes both, and they were very they were very experienced individuals, and their view is that whenever there's a project that has a multi-jurisdictional, a multinational aspect, 91% of the time they believe arbitration is the best remedy to resolve a dispute under an international project.
Perfect.
I think that's true.
And since when hocam October operational, we have a new arbitration center in Turkey. It's called İSTAK, Istanbul Arbitration Center. Ziya hocam is the chairman of Istanbul Arbitration Center. Just recently means 2 days ago, I was sitting in a negotiation and I proposed, okay, why don't we put the İSTAK arbitration rule instead of ICC? And of course the first reaction, no, we don't know İSTAK, we always go for ICC. Hocam, 2 questions to you. Or ACIA. ACIA is the short form of London Court of International Arbitration. ICC. And if it's an ICC arbitration, you don't have to go to Paris. The headquarters of ICC is in Paris. But you can have an arbitration according to ICC rules anywhere in the world, including Istanbul. So you don't have to go to Paris or Switzerland or elsewhere. You can do it in the US as well. But what are the differences between ICC, ACIA compared to Istanbul Arbitration Center? So is it really day and night kind of difference, or what is it, hocam?
Well, both ICC and LCIA and other institutes, they really facilitate excellent service to the practitioners, and they are very good institute. But also now you have an international arbitration institute in Istanbul, and our rules are very familiar with the rules that the arbitration practitioner are familiar. So therefore it is not different at all, but we have some advantages in Istanbul, such
But
as
you are a mainstream institution, so nothing fancy, nothing so very weird. It is more or less very much comparable with ICC and ACIA. Can we say that, hocam?
exactly, that was our aim when we made our rules. We wanted the practitioner to feel comfortable when they are in Istanbul. It shouldn't be something different or strange for them.
Not too much innovation.
Exactly, whatever they do in Paris or in London, they should have the same sort of rules in Istanbul as well. That was our main point.
And I assume Istanbul Chamber of Commerce was totally different. They were quite different than the mainstream arbitration institution in terms of operations, in terms of court.
Well,
That is my experience, hocam. Okay, you are very
let's be diplomatic and wish them
yeah,
good luck to them.
Hocam, I'm trying to create a little bit sensation because we are the unluckiest panel. So we are right after the lunch, so everyone is ready to sleep. So we have to keep them in a way concentrated on that. It's not easy. I'm trying to. So Ziya Akıncı said Istanbul Chamber of Commerce is nonsense.
You can.
He didn't say that, for the record. Indeed, there was a meeting within some practitioners to which I participated as well, and they tried to come up with some very innovative solutions in arbitration, etc. My reaction to that was, please don't do that. So I appreciate it's a great idea, but we have to stay in the mainstream if we want to be an arbitration center which will be used by the practitioners in a more common way. And hocam, is it expensive?
Well, it is not. Well, what is expensive, what is cheap, is very relative, but we need to compare it to say if it is expensive or cheap.
That's the concern of all the people. Oh, arbitration is very expensive.
Well, interestingly, the statistics says the most of the expense in arbitration are the parties' expenses. So, in fact, it is not the arbitration, but parties' approach may be expensive. So therefore, for example, we experienced some cases against each other, and it went very, very tough, but in a very gentleman way. And at the end, we settled. That is the happy end, we have to say. But the parties really can play with the proceeding, can be flexible, be nice to each other, be constructive, even can settle at the end of the arbitration. So therefore, let's talk about the expenses. Arbitration is not expensive as many people think. When we compare it to the court fees, in fact, we have a chart when we have time.
Can we show the chart, hocam?
Yeah, maybe we can. I don't know. I don't have the remote control.
Andrea, can we show the chart on the screen, please? So it is Istanbul Arbitration Center compared with...
Nice.
Oh, yes.
The last one, in fact, yeah.
This one?
Yes.
Yes.
So this is...
To you.
excellent.
This might be more helpful to you.
Yes, yes. Okay. Lovely. So this is a comparison to court and ISTAC fee, especially for the high amount dispute. As you can see, the difference is incredible, 10 times even. So courts are not cheap either, especially for the big cases, for M&A cases, is really very expensive. For the
Indeed,
small
hocam,
cases,
100 million lira is approximately 30-something million dollars, and it's a very common level of dispute if it's not higher. And if you go to the court, you pay more than 6%. Is that correct?
Absolutely. And for the small cases, in every circumstances, we try to be below the court fees. But the difference is really amazing when the amount of the dispute is high, which is most of the time the case in M&A disputes or construction disputes. So therefore, arbitration is not expensive, and the parties, if they have constructive approach, can control their cost
Indeed.
much better, of course.
A settlement in a court dispute is tough, but in an arbitration, to settle, in my experience, is much easier because the attitude of the parties, how the counsels manage the dispute, etc., is more friendly, practical, and kind as well. Well, in court, it's the real street fight, isn't it?
Yes, I mean, I think when we look at it statistically, the number of settlements reached during arbitrations is incomparably high when compared to those that were settled during litigation. So yes, I mean, arbitration can be started, but it may as well be the case that when both parties have heard the claims of each other, settlement is very common in an arbitration, but it's not that common in court cases. I very much agree.
I think there's another figure missing here, obviously, translation cost. So the arbitrators can operate in different languages. You can pick up an arbitrator who can speak the language of the arbitration as well, but if it's a Turkish court, you have to translate everything into Turkish, correct?
Yes.
And also in one of my experience, there was a problem between the parties regarding to translation.
What is the correct translation
Exactly.
of the
The
sentence?
court appointed an
Experts.
expert just to know which one is the correct translation. And then after this objection, etc., the case started when the translation issue is finalized. But in arbitration, in many of the cases, the arbitrators can have the language of the contract plus the other languages such as French or Turkish, whatever the case is, can be the language that the parties can present their evidences.
And parties can appoint their arbitrators, isn't it, hocam? Do they have to pick up one arbitrator from a certain list? Are they obliged, or is it the case?
In many arbitration institutes, the parties can appoint their the arbitrator, and also some institute provides list of arbitrators. In Istanbul Arbitration Center, for instance, we are not going to have such a list. That is ICC's and LCIA practice as well. I think the parties should be more flexible. Yeah.
And not give a certain privilege to the people, to practitioners which are shown in the list, etc. By the way, I'm still not in the list of the Istanbul Chamber of Commerce, hocam. You are not in the list either, as far as I know. Have they put you in the list?
Well, let's focus on
Again,
No sensation today.
maybe,
Are you in the list of the Istanbul Chamber of Commerce?
No, I'm not. I'm not.
Perfect.
While talking about costs, maybe can we also briefly touch upon this third-party funding concept? Maybe it may be a new concept to many of you here, but especially in the recent years, there is an emerging trend in international arbitration, and that's third-party funding. This means basically, if you want to go into an arbitration, but if you have hesitations to bear the costs and so, or if you're unable to at that point financially bear the costs and so, there are a lot of third-party funders that are willing to step up and bear all your expenses, legal fees, arbitration fees, even your plane tickets and everything, in return, of course, for a certain fee that for a certain amount payable to them when and if you end up winning the arbitration. For instance, currently we have a state investment arbitration where our client ended up because of its financial difficulties, going with a third-party funder, and they promised that if they end up winning, they would end up paying 34% of the amount that would be compensated to them. There are other examples as well. So this is a recently rising trend in international arbitration and arbitration.
It's a great opportunity, especially in exit cases, isn't it, hocam?
Absolutely. In investment cases, even the very big companies that has no financial problem, they may prefer third-party funder because they don't want to carry the risk or utilize their money for the court expenses, arbitration expenses. And I remember one of my experience with investment arbitration. Once I was asked to call a gentleman because apparently they had a trouble in one of the CIS countries. And then I called him and said, okay, there is investment arbitration. Do you know about it? He said, no, we don't have arbitration clause in our contract. I said, no, you don't need to have arbitration clause. We are talking about investment arbitration. Because of bilateral treaty, you may have this, right? And then he said, but we are really in trouble. This must be very expensive if we talk about international arbitration. I said, no, there is third-party funder. You don't have to pay anything. So if your case is good, you can refer to arbitration and you don't have to pay anything. And he said, okay, could you give your number? I'm going to call you. And then after 5 minutes, he called me and then he started apologizing. He thought I was joking or I was just cheating. And he realized I was the Akıncı that you mentioned, and it was true that he was very surprised. So for the investment cases, it is an excellent point because even if there is no arbitration clause in the contract, against the state, there can be an international arbitration, plus the third-party funders these days are very willing to finance the case. It's an excellent point.
Maybe a further question about Istanbul Arbitration Center, hocam, because the reputation of a center can be calculated based on certain things, but one of them is the court of that institution. So, who are sitting in the court of Istanbul Arbitration Center?
Can I have the opportunity to
Please.
just, in fact, I prepared.
I seen the names,
Yeah.
so very.
The names, just to answer your questions, are very, very well-known names. I mean, arbitration people know them very well. Other day, one of the journalists was interviewing me and asked who are the people in the International Court of Istanbul Arbitration. I was very excited. I said, look, Professor Jan Paulsen, Bernard Hanetoğlu, Dr. Amit Karavi. I was very excited and it didn't ring bell for the poor journalist. And she said, who are they? I said, look, for football, do you know Ronaldo, Messi? So they are the Ronaldo and Messi of arbitration. And next day, the heading was, arbitrations, Ronaldo and Messi are in Istanbul Arbitration Center.
Hocam, now I understand why you are so careful about all the questions.
So that is the people all the arbitration practitioners know, and they are kind enough to accept to be in the International Court of Istanbul Arbitration Center. Sometimes I lecture about Istanbul Arbitration Center abroad, and they say, okay, it sounds okay, but how can we know it is going to be natural? And I just pronounce those names, and all the questions are satisfied. So we are very lucky to have this excellent expert in our case.
So that professor title is not, it shouldn't be that misleading. They are not just professors, as you are. They are practicing professors.
Very, very well known.
Maybe another information for people sitting here. As you may remember, there was a major Turkish exit case some years ago.
Yes.
In that case, I can pronounce law firms' names. In that case, Turkey was represented by Freshfields. And that time, Jan Paulsen was the head of international arbitration practice within Freshfields. He was the one who set up the international arbitration practice within Freshfields. Correct, Hocam?
Correct.
Very reputable name.
Yeah.
Hocam, thanks very much. We all hope that we will see other success stories from the Istanbul Arbitration Center. We count on you, Hocam.
And if I may, I mean, we were also positively surprised. The rules were launched only at the end of October. And then, right 1 week or 2 weeks later, the giant project in Turkey, that is the third airport construction, apparently accepted Istanbul Arbitration Center as the dispute resolution method. I think this is a very, very good start. And we have just started to promote our center, but many Turkish public institutes already declared that they have been using Istanbul Arbitration Center in their general conditions. And also the private sector, the companies, they are extremely supportful, and especially TÜSİAD, we visited them. All the companies and private sector, I have to say I'm very grateful to them. I'm hoping that the project will be very promising. With your
Hocam,
support,
just
of course.
before we finish the arbitration center, Istanbul Arbitration Center issue, if the transaction lawyers organize a kind of small group meetings to learn more about Istanbul Arbitration Center, etc., would you join us and explain your plans, the content of Istanbul International Arbitration Center? So I'm trying to take a promise from you, Hocam.
By all means,
In front of
course,
everyone.
the transactions lawyers are so important because as long as the arbitration and Istanbul Arbitration Centers are in the contract, we can be successful. So therefore, I'm very, very much open.
Thanks
to
very much,
any
Hocam.
cooperation.
Coming back to M&A, I had a very interesting meeting very recently. The counterparty's attorney insisted on the following. He said, I don't want to deal with the following. We have to make sure that we have the identical provisions in the Articles of Association as well as in the shareholders agreement. Otherwise, it's very confusing. It's going to trigger unnecessary disputes. That was the wording he used. I said, I respectfully disagree, but you're killing the entire architecture of the agreement. He said, no, you have no clue about that. What is your experience? Maybe I was totally wrong.
Well, actually, no.
Or is it good to have identical articles or provisions in the shareholders agreement and the articles of association?
We also hear the same thing a lot from certain clients. They say the same thing needs to be reflected in the same way in each document and so. But it's not always a very good idea, because if you have the same thing in the Articles of Association and then the same thing in the SHA, and the SHA is subject to arbitration, whereas the Articles of
Which
Association...
is the case in many transactions.
Yes, and the Articles of Association and things arising from the Articles of Association of the company can be sued in Istanbul courts, then all of a sudden you may
So
end
we
up...
cannot agree on arbitration under the Articles of Association?
No.
Bad luck.
Then all of a sudden you may end up seeing yourself in a situation where you have sued under the provisions of the SHA for arbitration, whereas the other party has sued you relying on the same provisions under the provisions of the Articles of Association in Istanbul commercial courts, and then there's going to be a big conflict in between the two.
And Hocam, what about the following provision in the shareholders agreement? If there is a contradiction or if there is something between the AOA, Articles of Association, and SHA, the SHA will prevail. Does it solve all the problems Yalın explained?
Unfortunately, it doesn't. The arbitration clauses should be very consistent, if not identical. And if I may, I would like to give some very practical, if I may, advice for the practitioners.
For free. Thank you, Hocam.
For instance, in arbitration clause, instead of saying all the dispute arising from this contract, we should say all the dispute arising and in connection with this contract. So it makes difference. And the arbitration clauses should be identical. Otherwise, for the party who want to delay the procedure or have a contradict decision, there are so many guerrilla tactics. They can have
Gorilla or guerrilla, Hocam?
They can have different parallel proceedings, or even if there are different arbitration, they may appoint different arbitrators. For example, very recently, there were different arbitration clauses, but we wanted to have the same panel. We appointed the same co-arbitrator, even they challenged the arbitrator that we appointed, saying that otherwise he will be biased, so he should be a fresh person, etc. And once the decisions are contradicts, it's really a hell. I just started an enforcement litigation before Turkish courts, and not surprisingly, the respondent says this arbitration award made in Switzerland cannot be enforced in Turkey because only in share purchase agreement there is arbitration clause, but in the shareholders agreement it doesn't, and the award, of course, touch the issues in shareholders agreement. And now we are trying to convince the judge that in fact this is within the, or this was within the scope of the arbitrator. So there are so many troubles, but the solution is very easy. Just have the identical arbitration clause.
Or you can have an arbitration agreement which covers all the agreements as well. So you don't have to deal with different panels in that case.
Absolutely.
And coming back to the SHA and Articles of Association, so I imagine you can win the shareholders agreement arbitration and you want to enforce that in Turkey, and the counterparty says, excuse me, I have a court decision here, and the court does have jurisdiction. You cannot reject the jurisdiction of the court because of the Articles of Association, and the enforcement will be very difficult, if not impossible, isn't it, Hocam?
I mean, very easily one party may say it is a violation of Turkish public policy
I am
because
actually,
it contradicts.
I'm actually aware of an arbitral award where a big compensation was awarded, but which ended up being unenforceable in Turkey because of a similar mistake. So, I mean, put yourself in the position of your client. You arbitrate for 2 or 3 years, you pay all these legal fees, all the operational burden and everything, and then you end up winning the arbitration, you celebrate, you think now you're going to get all those hundreds of millions of dollars, only to find out that some months later and 4 years down the road, you have an unenforceable award. What a disappointment.
Hocam, what do you think? Should we go back to the audience and maybe they have questions? If they don't have any questions, we ask questions to them. Questions? No questions? You understood that all? Sure? Hocam?
Or the opposite.
Your floor.
Please.
Mr. Kaif.
Question on confidentiality. Is it also confidential if you execute the award that is awarded by the arbitration institute? Is that something third parties can have insight in, or is that also being treated confidential?
The enforcement of the award through the courts.
Yeah.
Court hearings are public. Full stop. Not the files are public. However, in reality, they are public as well in a way.
If I may, it's an excellent point. Sometimes when there is an enforcement issue, the client says, okay, is it going to be public or we need confidentiality? In many jurisdictions, not only in Turkey, this is an issue because it is very difficult to get a decision from the court that it shouldn't be public because of the constitutional principle. But the difference is, if the substance matter is going to be decided by the judge, so all the information is available practically in the court. But in enforcement cases, practically the court only examines if the award is enforceable or not, such as if there is an arbitration agreement, if the due process was violated, not the substance, but only the grounds to enforce the award. So therefore, you are perfectly right. Before the courts, the discussions may be not as confidential as in arbitration, but anyway, what is discussed in enforcement proceeding is only the grounds of enforcing the award, not the substance.
And you don't submit the entire file to the court, you submit just the award to the court.
Correct.
Questions?
My question is about those founder companies. What kind of companies are these who fund the arbitration costs in general, and how do they find about the parties in dispute who require funding? What is general practice, and how do they meet each other?
Hocam?
Buyurun hocam.
Some of them are banks. I experience proper banks. Some of them are only financial institutes. Some of them are related to insurance companies, or some of them, or most of them, are specialized in funding litigation and arbitration.
There are currently 4 or 5 third-party funder companies that we frequently work with. None of them are based in Turkey. They're based, some of them are based in London and some in Paris, but we regularly work with them. It's not usually them finding you. I mean, there can be instances where they find you as well, but most of the cases when one of our clients tell us that they want to also see if they have a third-party funding chance, we set up meetings with the representatives of those 4 or 5 third-party funders and our clients and see if we can have some sort of a deal. So it's most of the time, in my experience, the client finding those companies, and there are, as Hoca has mentioned, there are very reputable third-party funder companies that only do this business.
Kerem Bey.
One small question. How long does it take to take the decision and then to execute it? Ballpark, and compared to court.
In an M&A arbitration, I would say so, year and a half until you come to an award. And the enforcement under normal circumstances is not a big deal because you don't go back to the entire file, you just submit the award to the court, to the respective court, like in Istanbul. And the reasons to reject an enforcement is limited according to some international bilateral, multilateral arrangements like New York Convention. Or if your seat of arbitration is Turkey, it's a Turkish arbitral award. It's even easier to enforce. You just go to the execution office.
Talking about time, if I may, sorry.
Of course, Hocam, please.
I just would like to mention that Istanbul Arbitration Center, first time in Turkish practice, introduced fast-track arbitration. That is, the dispute is going to be solved within 3 months. Of course, if the dispute is complex, it may be short. The parties doesn't have to agree to fast-track arbitration, but it is very doable, and we will practice it. It is very convenient for Turkish practitioners. And I think it will be an excellent solution. And the advantage will be why it is going to be finished within 3 months, because the arbitrators will be the expert, because there is not going to be most probably appointed experts. And if the dispute is not particularly complex, it is very suitable with the Turkish litigation and arbitration practice. I'm very optimistic about this fast-track arbitration practice in Turkey.
And what about injunction, Hocam? For instance, I have a call option under the agreement, and I have exercised my call option, and the counterparty is reluctant in terms of handing over the shares, and is trying to transfer the shares to a third party. If you were talking about a court, you can ask the court to give an injunction on that. Can we have a similar situation in arbitration as well? Because otherwise, having a call option is a wishful thinking only. So, what is your experience on it, Hocam? Or your recommendation, your advice, free?
Well, let me start with my experience. There was one experience, exactly what you described, and the claimant asked for an injunction, I think, late afternoon on Friday, and then got the injunction not to transfer share in the middle of the night on Sunday. So that was very efficient. And the arbitrator, the chairman, was extremely clever. He said, I'm going to hear the parties about the injunction, but until I hear the parties and to decide injunction, I order the respondent not to transfer the share. So it was sort of injunction of the injunction, but he managed to protect statu quo. So the shares were not transferred. It is very efficient. And under Turkish law, now the injunction by the arbitrators can be enforced, like the court decision. And in practice anyway, the parties obey the order of the arbitrators because they don't want to upset the arbitrators who are going to decide on the merit after a few months.
Everything is more friendly, hocam, isn't it?
Yes.
Rather than in front of the courts. Our time is over, I think. If there is no further question, I will thank to my very distinguished panelists, and thanks for listening to us. Thank you.
Thank you very much.